I want to talk to you guys about a lawsuit following the denial by New York Life of an appeal. And 99% of the New York Life policies, unless it's through an association, but the ones that are employer provided are governed by the law of ERISA. And ERISA, as you guys know, is this animal. I call it an animal because it has these rules that make lawsuits in federal court like nothing anyone's ever seen. It is not the stuff that you see on television that we all grew up watching thinking like, I want to be a lawyer for. Right. It's not that. It ends up being this written brief, and it's a battle of the papers, and you better have a damn good lawyer who knows how to do ERISA, who knows the law in this world, which I call the wild, wild west, because there are thousands of ERISA disability lawsuits, and they're all over the map. But Rachel, there are challenges that come with this, besides me just saying it's an anomaly. Talk about why these ERISA lawsuits and the way the law is are challenging and not that tend to favor the insurance companies more than the claimant.
Right. Well, it's a law that was written in 1974, and they pretty much have barely changed it. Here and there, they make amendments, but essentially, it favors the insurance carrier because the claimant has the burden of proving that New York Life was arbitrary and capricious in denying the claim. And what that means in layman's terms is that New York Life didn't even have one reasonable basis. So all New York Life has to show is that they had a reasonable basis to deny this claim. And the judges are mostly conservative federal judges. They look at it and they say, okay, well, they had one reasonable basis. They had a peer review doctor, a neurologist, for example, review a claim of a man who has Parkinson's and say, oh, well, I think, he can work. His disease isn't as bad as his treating doctors are claiming. And they did a peer review, and the peer review says, well, I disagree with this doctor. And the judge looks at it and says, I find this reasonable, and that's a reasonable basis. Therefore, the claimant loses, and the insurance carrier wins because we didn't prove that they were arbitrary and capricious in denying the claim. And unfortunately, with ERISA, with these ERISA cases, it's basically a one-day bench trial, and there's no testimony. There's no discovery. So in like you said, in the trials you see on TV where people stand up in front of the court and they're picking a jury and they're testifying and questioning people on the stand, none of that happens. The judge doesn't even get to meet the claimant. So the judge doesn't get to, there's no contact with the claimant's lawyers, the claimant's doctors. It's just reading a stack of paper and a judge deciding, hey, from what I've read, is this, was the denial arbitrary and capricious? And I would say a majority of the time, the judges find in favor of the insurance carriers, not because the claimant isn't sick or doesn't have an issue or isn't possibly disabled, but that they find a reasonable basis for the denial. And this is why it's so difficult to win these cases. So when we do our appeals, we have to do our best to prove in our appeal that there was not a reasonable basis to deny this claim and, put it all in there. So when the judge does read these files, they do get the impression that, hey, New York Life was unreasonable in denying this claim. They should never have denied it in the first place, and they rule in favor of our claimant.
I think, Alex, in order to win these lawsuits, that you have to know the case law. Like you just have to have this understanding, and whatever court, and it's a federal court where you end up filing this, that you can take that case law and make those strong arguments. Now, when we go against New York Life, we've handled thousands of lawsuits against them. It's not like we're someone who shows up and they're like, oh, this law firm doesn't know what they're doing. This isn't a hobby for us. This is what we do every single day and have done with them for the past 20 years, an extensive amount. So they know we know exactly what we're doing. And it comes down to the fact that they're going to put money on the case, because they're going to feel risk. I've rarely ever seen a case, and it's not a case that we would take, where they just go, no, there's no way you're going to win. They don't do that. Now, I'm not saying they think they're going to lose every case, but they understand that as bad as we talk about ERISA, and I called it earlier the Wild Wild West, for every case that we find that would support a fact pattern that matches unreasonable conduct that we believe New York Life conducted, they're going to find a case that a judge said this same exact conduct that you're saying was unreasonable, this judge found it was reasonable. Now, I went to law school at Cardozo, and Judge Cardozo wrote The Nature of the Judicial Process. And he basically said that judges bring their personal opinions, beliefs, and life experiences to the courtroom. And they all do. And we see that on every issue when a judge makes a decision, if it's an abortion issue, if it's an immigration issue, or whatever, because they have backgrounds and experiences. Same thing applies here. You could get a judge who said, I've been on the bench with my bad back for 40 years and you're telling me you can't go sit at your computer? You don't have a shot in hell of winning with that judge. And then you get the other judge who's like, who is sympathetic, who's a pro-claimant. So many factors go into this, but you have to have the experience, and there's risks that go into this. But Alex, just touch on a minute, because of the risks, there's no guarantees in these things, about how these New York Life cases can resolve, whether you go through to a verdict or you reach a settlement.
Well, with any lawsuit nowadays, most courts require they go through a mediation process. And even before mediation, you often have conversations with opposing counsel to say, hey, want to talk numbers on this case? Send me a demand. Maybe we can settle this prior to mediation or at mediation. And a settlement is basically just a lump sum saying, the insurance company says, all right, we'll give you this amount of money to go away, and it'll be a complete divorce, no takey-backsies. There's no more coverage under this policy, no more future coverage as well. A lot of the times, it's basically, here's a lump sum of money, and go on your separate way. And if you go back to work at another employer and become disabled again, if it's coverage with New York Life, we're not covering you again. And a lump sum could be a good thing. Maybe you have a low shot of winning because ERISA really, the employer, it should actually stand, it stands for the Employer Retirement Income Security Act, but as we also often say, it's the Employee Really Is Screwed Act, because the laws really do favor the insurance company. But even though they favor them, we still have a lot of success here. But a lump sum settlement will give you certainty where there is no certainty. How we value these claims depends on your net monthly benefit. And oftentimes you have to take into account Social Security disability, whether you're getting it or not. We still have to take it into account when we're valuing your claim. And we do a present value calculation. And oftentimes the settlements are anywhere from 10% to maybe 40% of the present value of the claim. And someone's going to say, why would I settle for 10% or 20% or 30%? Well, ERISA is hard to win. And again, a guaranteed set amount of money, it might be higher than your odds of winning the lawsuit. We put our clients in the best light favorable with our appeals to make sure they get the most money out of any settlement. But a settlement might be the way to go. Sometimes the insurance company comes with terrible money. They go, no, we're going to offer you this amount of money. And I say to myself, that doesn't make any sense because you guys are wrong. And secondly, we have a good shot at winning this lawsuit, or there's no incentive for my client to take the settlement, and we go forward with letting the judge decide. And sometimes that's in my client's best interest. I never push my client to take a settlement they don't want to take. I tell them what I think their odds are, and what I think, what is in their best interest. But I tell my clients, you're the pilot, I'm the navigator. I can tell you to turn left. If you want to turn right, you can turn right. And we go forward with the case that my client wants to do so, but we hopefully lead them to make the right decision for their case. If it's going forward and letting the judge decide, then so be it. And sometimes it is in their best interest to do that. But like you said earlier, some judges, and we look at some of their rulings, we know who appointed them. You can kind of get a good feel whether they're going to be more pro, plaintiff or more pro defense. And then we make an educated decision for our clients.
The other thing we do, Rachel, from our experience, I know with every client, is that when you do thousands of these, you kind of have an idea of what the value is going to be. And we're not going to be one of those law firms that you call and be like, oh yeah, we're going to do X, Y, and Z, when in reality, we're going to tell you up front, like, if this case is never ever going to be worth more than $150,000, that's what it's going to be. I've never ever seen them offer more than that. And if that's not something you want, we're letting you know, we're letting you know up front, this is where it's going to be. And then we gear up, we get, and there's some cases where we go, look, you have like a 1 in 10 shot of potentially winning this case. We can pursue it, but have an understanding that if we go forward on this, and I think you have a 1 in 10 shot, which is really bad. If you lose, you could be exposed to their attorney's fees. Vice versa, if we win, there's a prevailing party only in a lawsuit, which is great.
Yep.
To have attorney's fees, which is a wonderful thing at ERISA, because outside, that's one of the biggest benefits of ERISA, in my opinion. Outside of that, usually there's no prevailing party attorney's fees in most states. So, but there's risk to going forward with this. And then we all sympathize with our clients. How many months by the time you get to a lawsuit have they gone without benefits?
Right.
I mean,
a lot.
At least, they've gone at least a 90 to 180-day elimination period. Now they've gone through an appeal, which they had 180 days to submit, plus they have, 45, 90 days to get a reply. Nobody's ever less than 1 year since they've been paid. So they're burnt out, they're frustrated, they want to get done with the insurance company. But on the flip side, often they just are like so burnt they don't want to do anything. But I like to tell clients, as I know you do all the time, it's no burden on the client for us to take the lawsuit.
Right.
Because a lot of people want to give up. They're like, I don't want to fight them. They're $1 billion company. We thrive on that. I love, we're this, we're a nice sized law firm. We have 13 plus lawyers doing this type of work, all the resources in the world to go up against them. So claimants shouldn't feel like I'm the little person going up against this monster. Yeah, New York Life's a multi-billion-dollar company, but it doesn't matter. We'll make them fold and we can go after them. So feel confident with that kind of thing. If you're someone out there with a New York Life long-term disability denial, feel free to reach out to Rachel, myself, Alex, any of our lawyers. No matter where you live in the country, we're available to assist you, and we'll always provide you with an initial free phone consultation.